titled The University as a Community of Speakers. And we touched on these issues already this morning and this afternoon. And the university is, as Barak Medina said, free speech is complicated. And even between me and Barak, we have some difference of opinions. While he puts more weight, we're both pro-free speech. Okay, let's make this, but within this framework, he puts more weight on free speech versus protection of the community, and I put a little more weight on protection of the community versus free speech, and there's a dialogue there, which is good because we have free speech. So this is what we're going to focus on in this session. We can look at in community, and we are a community, academic community, whether it's within physical borders or virtual borders. There is something about belonging to an academic community. And the question is, does this carry with it some alteration of the norms that apply to free speech? Does the fact that I'm part of this community, however we define it, does it mean that I have more freedom of speech, maybe less freedom of speech? So these are the questions, whether the limitation on free speech is internal to the right or an external to the right. This is legal analysis that we're sometimes doing. We have three speakers. One of them, unfortunately, could not join us today. Smita Korana couldn't enter Israel, so there's freedom of movement here issues. And the restriction came too late for her to appeal this. So our first paper, our first presentation, is by Professor Einat Albin and Professor Ayala Hendin, Freedom of Expression as a Quasi-Social Right, a Dynamic of Liberty, Equality, and Dignity. Einat Albin is a professor of labor law at Hebrew University in Jerusalem. Her work focuses on workers' rights and service economy, workplace data protection, AI regulation at work. And I'll skip where you got your doctorate. And is a faculty member of the Department of Politics and Government School at Ben-Gurion University, and in recent years she was the Israel Fellow at Washington University in St. Louis, Missouri. So Einat, you start, and then Ayala. And you have about 15, 16 minutes, and I will police this.
So hi everybody, really nice to see everybody here. My name is Einat Albin. I'm professor of labor law at the Hebrew University of Jerusalem, and actually I come to think of freedom of expression through work I've done on freedom of expression during war times in employing organizations. And last year I was in sabbatical in London, and Ayala, who was a postdoctorate student at the Minerva Center for Human Rights that I was academic director of, came to visit London for a conference, and we sat for coffee, and I expressed my concerns on issues regarding freedom of expression and the way they are managed by the law. And she said, wow, we have very similar experiences in higher education in Israel and where she was located at that time in Washington University. And we started thinking about how can we think differently than current literature does on freedom of expression in institutional settings such as employing entities, higher education institutions, and governments, whereas opposed to balancing or seeing the tensions between freedom of expressions, equality, and dignity, we can think of a different dynamic among them. And so this is where our different backgrounds, Ayala is a higher education researcher, came together, and we offer here a new theoretical framework to think of these issues that we call freedom of expression as a quasi-social right, calibrating the dynamic of liberty, equality, and dignity. Now, all three institutions that we're talking about, employing organizations, parliaments, and academic institutions in the US as well as in Israel, and we're focusing mainly on US law, are obliged, most of them, are obliged to norms of freedom of expression to norms of equality and to norms of dignity, even if not directly, then indirectly, and various norms that apply to all these three institutions. And in these institutional settings, we found in the last few years several situations where conflicts over speech erupted the three institutions. Students were suspended, or actions were taken against them for expressions of their ideas, of protests. Employees were experiencing actions taken by their employers, including dismissal for political expression. And a legislator invoked free speech to justify language that many experienced as degrading or exclusionary. And in all these situations, the same tension appears, and it was also very much evident in the discourse that we heard so far in the conference. Institutions find difficulty in fulfilling their commitments to freedom of expression and at the same time to their other obligations, including equality and dignity. Now, the dominant academic discourse, as I said before, around these issues offers very little guidance for navigating this tension. It continues to treat freedom of expression primarily as a negative liberty, a right against interference, largely abstracted from institutional structure, hierarchy, and compulsory communicative settings, and aims to discuss freedom of expression on the basis of limiting freedom of expression or as an opposition to equality and dignity. Our article builds on previous pieces of work that argue that this framework is not sufficient in these settings, and that the core difficulty is not simply where to draw limits on speech, but how freedom of expression can actually operate within institutions, i.e. we focus on the manner of speech. And on this basis, we offer this framework of expression as a quasi-social right. So I will take a few minutes to explain this idea and provide you with the theoretical understanding of our framework, and then Ayala will give examples of practices and norms within higher education institutions in the US and in Israel that already adopt some of these practices. So, indeed, in the literature, what we see is a binary debate, which is both doctrinal and scholarly, that sees liberty as opposed to equality, autonomy as opposed to dignity, and free speech as opposed to anti-discrimination activities. On the one side are autonomy-based theories of freedom of expression grounded on self-realization, liberty, non-interference. They tend to favor minimal restrictions and are deeply influenced in First Amendment jurisprudence. On the other side are equality and dignity-based critiques emerging from feminist theory, critical race theory, democratic theory, which emphasize how speech can subordinate, silence, or exclude through hate speech, harassment, or structural power, asymmetries, other voices. Importantly, both camps focus on the same question, when and whether speech should be limited. But the problem is that once an institution, like higher education institutions, are obliged to norms of freedom of expression together with equality and dignity, it does not necessarily have to go through the binary discourse, but rather we can start to think of a calibrated dynamic where liberty, equality, and dignity can actually come together, with the focus not being the limitation of speech, but rather ensuring all forms of speech, but rather move to look at the manner of speech. Now, this is where we draw the middle ground scholarship. All of this is mentioned in the article. You can see the entire breadth of scholarship on this issue, but we're particularly referred to Cynthia Estlund's work regarding the labor market, on workplace speech that emphasize the manner of speech as opposed to restrictions of speech, Shana Schifrin's work that emphasizes, again, manner of expression. Re'en Segev from my faculty also noted in a recently quite important article that there should be a move in the discourse from limitations on the scope of speech to manner of speech, to how we express our ideas. And these accounts shift attention away from content-based prohibitions toward how speech is expressed, received, and engaged with, to the manner of how this is experienced. And what we look at are conditions for realization where we think institutional settings can play a very vital role. They can promote, facilitate, and create ways in which all ideas that are not legally prohibited by criminal law, but all other ideas that are not legally prohibited by criminal law can be expressed within institution in a facilitated way that focuses on their manner as opposed to their limitations. And on this basis, we develop our idea of freedom of expression as a quasi-social right. Now, what do we mean by this?
You reached the half of your time.
Okay, so I'll do it really, really quickly.
One more.
Yes. Okay, so as I said, traditionally freedom of expression is understood as a civil and political right, only framed exclusively in negative terms, against interference, focus on boundaries. By contrast, a social right like education, healthcare, or welfare concerned not with non-interference, but with conditions of participation. They actually impose positive obligation. They are outcome-oriented. They ask not merely whether a right exists formally, but whether people are actually able to exercise it in a meaningful way. And our claim is that within institutional settings, we can focus our attention to this idea of freedom of expression as a quasi-social right, so that institutions can use their staff and their facilities to indeed sustain and uphold freedom of expression in a dynamic manner, and this is why we call it a quasi-social right. The idea is to calibrate a dynamic of liberty, equality, and dignity, and the assumption is that if this dynamic will be facilitated through the institutions, in the end we will actually fulfill all the rationales of freedom of expression, because it is only by ways in which we can hear and engage with ideas that we can reach self-fulfillment, that we can think of searching for the truth or conduct a rigorous inquiry of the situation. We can enhance democratic participation, again, only by listening to each other in a manner that enables such listening, debating, and speaking. We can reach social stability and increase tolerance, which are the 5 core ideas of freedom of expression that cannot be fulfilled if we're only talking about one against another in a balanced way and limiting speech, but rather by adopting policies that facilitate and enable all ideas to come forward within this setting, and Ayala will give some examples on how this can be done in higher education institutions.
Okay. So moving from the theory to practice, we looked at 3 different venues, at workplaces, at legislative bodies, and higher education. I'm going to focus mostly on higher education within this conference. And we identified 3 paths in which this new way of thinking about free speech can happen. We already know that protecting free speech is going on in the legal path, okay, protection. We are going to be focusing on facilitation and promotion, and claim that that's also already happening, and claim that this can help us strengthen free speech. When we move to manner versus content, we're not trying to simplify things. We actually think that the manner might be helpful in thinking about free speech in a more substantive way. Okay, so I'm going to go really fast through the first 2 paths. The first path is legal protection, and in higher education, we all know Title IX as a classic way as a classic protection of dignity, of equality. More classic binary approach to this would look at Title IX as limiting free speech, okay? Either limiting or enabling free speech. And we are suggesting looking at it as a dynamic where dignity and equality are protected by the law, enabling more individuals to take part in the conversation, therefore enabling more substantive freedom of speech. The second is what we're calling facilitation, giving here examples of procedural facilitation through parliamentary deliberation or employee due process. Once again, the binary approach would look at it as either limiting or not limiting free speech. We are looking at it as an enabler, as something that allows more people to take part in speech and allows for more substance in the way that they can express each other, each express themselves. The third path is the one most relevant to the higher education context. And here we're looking at three types of practices or procedures that once again strengthen free speech rather than limit it. Okay, the first one we heard a lot about, I think in the first session today, mission statements, codes of conduct, various written forms where institutions say something about the atmosphere that they want to create within them. The second is a restorative process. In the last session, Professor Pnina spoke about the Hebrew case of Professor, I don't want to mispronounce her name. Okay, Professor Nadila. One of the interesting things that the university did is after the formal process, they started a restorative process as well to allow some kind of deliberation within the faculty of the institution to think through what was done and to think forward of rebuilding. The last practice, whoever works on DEI is very familiar with different teaching and learning workshops and sessions, also for students and also for faculty. We understand these as another type of intervention that is supposed to help facilitate and promote speech that's thinking about manner in addition to content, that's asking questions about where speech meets community and not only liberty. Okay, so those were the examples, and I want to go move on to counter arguments. Right? We know that there's many counter arguments for thinking about free speech as a social right, a quasi-social right. The first would ask: is freedom of expression not absolute? Okay, and to this we answer that there's already limitations in the law to free speech. But in addition, quasi-social right is thinking about strengthening and not weakening, about how we are widening opportunities for speech and not limiting. The second counter-argument would be, is existing law harassment definition sufficient or not? And we think about the existing laws as prohibitions or the backstop. Quasi-social right is about facilitating and promoting substantive expression and not only limiting ideas. A fourth counter-argument would be about dignity and equality being subjective. And here we argue that this is the role of institutions. The institutional context is supposed to turn whatever is subjective into more formal objective procedures within the institution. And last, does democracy not require angry, undignified, and offensive speech? And to this we say yes. Okay, we think that there is room for all of that. However, we do differentiate between the characteristics of a public sphere and an institutional sphere where there is ongoing communication and engagement that requires thinking about ideas and concentrating on debating ideas rather than insulting, degrading, silencing, and so on. I am ending. So our suggestion is to move forward to thinking about freedom of expression as a quasi-social right. We're protecting liberty alongside facilitating and promoting equality, dignity, and liberty practices together will enhance substantial freedom of expression.
Thank you, Einat and Neta. Switching the paradigm. So our next speaker is Noam. Noam is a professor of economics and public policy and business responsibility, emeritus 5 days ago, right?
4.5.
4.5.
Time difference.
At Columbia Business School, the director of Columbia Institute for Teleinformation. He authored 37 books and hundreds of articles, and among numerous public positions, he was appointed by the White House to the President's IT Advisory Committee, just doesn't say which president.
Was Bush the younger.
Okay.
Not Trump.
Thank you. So Eddie will talk about organizing for free speech on campus, Columbia lessons.
Thank you. But I should also add, since there was a Republican, but I was also appointed to the New York as a New York Public Service Commissioner by a Democratic president who was the father of our governor who just got defeated trying to run for mayor of New York. So I was already introduced, Professor of Economics, and my field is the economics and policy of media and communications. My field is really not academic freedom or freedom of speech. I'm married to freedom of speech, but I've been involved in the Columbia University Senate, where I had some leadership role in a variety of ways, including getting a resolution on free speech adopted about 7 or 8 or 9 years ago. And it was adopted, basically its principle was the rules of free speech that apply outside of campus also apply inside of campus, which doesn't seem to be incredibly controversial. It took 2 years to get the students on board, and I never got the university president on board, who is, for those of you who are legal scholars of First Amendment, you probably know Lee Bollinger. He was president for 23 years. He's a really good scholar. He's a real good advocate of free speech everywhere else except where he has administrative power, because there he is a CEO and not a legal scholar. And so, and I'm at Columbia also co-chaired and co-founded 2 free speech organizations, one for the faculty, the Academic Freedom Council, and one the student Columbia chapter of the Heterodox Academy, which is primarily geared at Columbia to students. So I don't have a paper, but I have some thoughts and analysis and interpretation and conclusions and maybe even remedies if I get to them. Now, in economics, because so many here are lawyers, I actually have a law degree too, I have to confess. But too much time. So translated to one of the paradigms of economics is that structure determines behavior, and behavior in turn determines performance. And so applied to the subject matter at hand here is that the structure of the organization, university, determines and affects its internal behavior, its culture, which in turn determines its performance, such as free speech. So this is a pretty materialist type perspective. And I would, in that light, argue that you can establish a regulatory speech rules and regulations on the university level all day long. The problem are not the rules. They don't make a huge difference. And the margin maybe. And you can also wring your hands all day long asking for civility and tolerance. Why can't we be all good friends to each other, etc., etc. But it won't make much of a difference either. It feels good. Ultimately, it's the organizational culture that permits free speech, that nourishes free speech, that protects and promotes free speech. And that culture is the culture of the academic community, an overarching common interest in the performance of the organization. Now, where does this all come from? Let me go back just a little bit, like 2,700 years. We are, after all, here in the Middle East, where time horizons are long. It goes back at least to the Assyrian king Assurbanipal. I'm sure you're familiar with him, who kind of established the royal library in Nineveh, which stocked over 10,000 works. And documents were arranged in different rooms by subjects, such as biography and religion and commerce and legends and hymns. Each had a separate room. Each was occupied by some scholars, priests and scholars, in turn surrounded by their students, probably fighting with each other. And so you had already the kind of basically the university structure of today, kind of a large institution with separate departments and faculty and students, and some contributing also to the learning, astronomy and stuff like that. And that was a system that kind of continued and was passed on through, say, the museum in the library in Alexandria, and then kind of migrated to Europe, Bologna and Paris, and then kind of blossomed with particularly the German university system in the 19th century, which added to that not only a stronger research component, but also the concept of academic freedom, so that the professors were not just kind of civil servant teachers, but they were also had certain independence of their own beyond that of a regular civil servant. And that model continued into the 20th century and increased with in time, and universities grew and blossomed. But as they grew and blossomed, the centrifugal forces were also kind of increasingly strong, so that people in these huge institutions didn't know each other anymore. And that continued. And particularly in Europe, I think it is much stronger than the United States. The centrifugalism, for example, the University of Hamburg, I believe, had or maybe still has, two separate law schools, faculties in the same university, because they couldn't get along with each other, so they just split. There was law school A and there was law school B. So maybe we'll get there too. But in America, I would argue there was more of a sense of community. And there are several reasons, and one of them is the college system. That is, that undergraduates are not kind of coming in there already, at least in many universities, not quite into a professional training, but it's more of a larger college. Some of it is liberal arts, but even in the non-liberal arts programs, you have to take some science, you have to take some humanities. So there's more of a cohesion. The students live in dormitories, they eat, they party, there's fraternities, and so on. There's more of a cohesion. And then there are college sports. And I know, my intellectual types, this is kind of, you can laugh about this, right? But it is a really powerful integrative force across disciplines, across regions, so that the university is kind of like the University of Illinois, so everybody's in favor of the University of Illinois playing soccer, playing football against the University of Wisconsin. It creates a certain solidarity and a sense of community that goes beyond the departmental separation, and it also is an integrative force across alumni, across generations alumni, and it makes a difference. And they all root for their alma mater, and the word mater, of course, is already tells you that there's a sense of family here. If you're part of the family, you have loyalty to it, you serve it, you donate to it. In the outside community, the state takes pride and allocates tax money to it. And on top of that, the federal government in the United States gives also a lot of money to it because of the national consensus. Universities are an essential part of national economy and technological growth and for social mobility, and especially after the Sputnik shock in the 1950s, a lot of money came to the universities, and that developed strong and well-funded communities. And I believe a major factor for American universities to become the world's best, at least for a long time. So the university was more than an office park of different departments. It was a joint enterprise and a commons. But as often is the case, the commons was also used and abused by some of its members. And what happened is the classic case of what is called the tragedy of the commons. Lawyers often use that phrase. And so now the community is under serious challenge. There's a lot of centrifugalism, a lot of fragmentation, and the results of this have been an external questioning of the funding and support, and externally and internally, an inability to govern effectively. So, my own experience is that of Columbia. I mean, I hang around other universities too, but Columbia has been the focus here, and it's a great place. I should start with saying this, great people. But the events at Columbia, unfortunately, has made it somewhat of a exhibit A for American universities, having problems recently with free speech and academic freedom and student rebelliousness, etc.
Anti-Semitism.
Pardon?
And anti-Semitism.
And
Yeah.
very true. I mean, partly it's because New York
Exhibit
City.
A, A is for. No, that was a joke.
Partly it's because New York City is the media capital, and so it's kind of convenient to be covered. The TV crew can all just kind of go into the taxi cab and there they are. And so it was convenient. And partly it's because it was true. Columbia has always attracted rebellious students and faculty, and historically, and partly because New York City itself has a very strong activist community. So when something happens at Columbia, then kind of 10,000 people from the area show up in front of the gates, whether the gates are open or now they're closed. But they're out there in front of the TV camera and they make a lot of noise. And it gives the impression that the whole university is kind of like supportive because there's so many people there, but it's not quite true. But so what are some of the reasons for Columbia, but I think as an exemplar for other universities, for American universities, to be there. What happened at Columbia, just to briefly say, there were pro-Palestinian protests, of course, encampment with tents, and I believe that was the first that this has, that kind of was the model for other universities, these encampments. There were building occupation. We've had 4 presidents in 2 years. We're looking for the 5th. Anybody here? All right. There were police actions. There were arrests. There were no indictments because we have a district attorney who doesn't believe in anybody being indicted except the President of the United States. We have student referenda on divestiture, divestment, etc. And there were building occupations. Then, okay, so this is already the problem from the inside. But then Columbia, on top of it, had the problems from the outside because we were held in violation of Title VI by the Department of Education, and the Trump administration more generally kind of focused on Columbia as and kind of brought some charges against us and blocked any funding for the university significant. So that was kind of $400 million were blocked, and people's research was seriously affected. They had to let people go, and some people could not come to doctoral students. I mean, there were real problems. So then Columbia negotiated.
5 minutes.
5 minutes, all right. I have 25 minutes to go and 5 minutes, all right. So then, okay, so Columbia kind of negotiated a deal with the federal government that also is now kind of been somewhat of a model for other universities. And when it entered that deal, which is $200 million in some kind of penalty, plus $20 million to go to the victims of this anti-Semitism that had been observed, it was roundly castigated by many other university academics. And how could you give in to those kind of university bashing Trump administration? You should resist. Well, it's easy for other people to tell us to cut down on our medical and physics, etc. research. And it has also the further inconvenient fact that we were actually guilty. All right. So this would have been clear. We would have, in my view, clearly lost the case. But 2 years later, and in the meantime, no money would have come along. It was just the right thing to do. And the conditions actually were not onerous. There were 9 things there, and I don't have the time to go through them. But basically, they had clearly sources inside who knew what already faculty people wanted, or some faculty groups advocated. And it was not much more than that, except that it came, the objectionable thing is that it came from Washington, rather than it came internally. And that is the problem, and such as the Columbia problem. The absence of self-reform led to a counter push from the outside. If you don't put your own house in order, somebody else will come and make you do it. And it's regrettable that it was the Trump administration. We should have done it ourselves. Other universities should have done it themselves, but they haven't. And so a system in which basically universities and faculty and even students kind of understand that there's some consequences is actually a moderating type force. And possibly Columbia and now Harvard and so on are kind of examples for everybody else to mend their own ways, to self-reform. Okay, so without the government stepping in. Now, let me just jump a little. Okay, so there are a good number of reasons why the community has been breaking down, and I don't have, they're financial, they are structural, they are in a variety of ways. In particular, that departments had established such autonomy that they became kind of like islands to themselves. And within the departments themselves, also individuals. And this is where the tragedy of the commons come in. Everybody was doing their own thing. For example, the Middle East Studies Department, so actually, for example, it's the extreme, was totally dominated by anti-Israel voices. This goes back to Edward Said, who kind of started and structured this department. I served with him on the publications committee of the Columbia University Press. That was many years ago, and it was quite clear, it was totally political in his selection of books, and ideally he wanted a quota system. If we have books accepted by 2 white guys, then you had to have at least 2 or 3 non-white guys there, and this is before many of these things happened elsewhere. And he was totally political in his book selections, and he was totally doing favors. He was hiring in that fashion. He established departments. The spirit of departments that was essentially activist rather than intellectual. But it was masked by the fact that he was a respected and well-known academic and intellectual. And so we had then the Middle East department that was essentially totally anti-Israel. A few weeks ago, the anti-Semitism task force at Columbia, something that was appointed by the president of the university 2 years ago, came out with its third and final report. That said that of 20 faculty members, there's not a single person there who is supportive of Israel or anything of that nature. And so you have these bubbles, and they get funding from God knows where, or Allah knows where the money comes from. So that is the problem. Now, what can one do about this? I will just give you 5 bullet points because the chairman's breathing down my neck. Okay, the first one is to reestablish the balance between individualism and community as a university. One has to invest in an infrastructure of community integration. These things don't happen by itself. They have to be organized, they have to be managed, there has to be money into integrated forces, interdisciplinary, intercultural, a variety. Hand-wringing here is not enough. It includes also the use of technology and integrated forces. Secondly, reduce financial dependency, and that requires a shrinking of the university. Nobody likes to shrink anything. Everybody wants to grow. The problem of the universities, certainly in America, and I'm sure here too, is that they're just overexpanded. And therefore, they're continuously, even a university like Harvard, even a university like Columbia, there's never enough money. And so therefore, you have to compete for grants, for faculty, for students, everything, and you have to, and the government has significant power, therefore. Thirdly, recreate an academic culture instead of a political culture. Mm-hmm. And that partly can be done in a variety of ways. My favorite one is end grade inflation, make courses harder, get students a little bit busier because they kind of have less time to worry about Gaza when they have to worry about physics 202. And the students actually students take their incentives. And for example, you have one more example. Okay. All right. Students get extra time if they have a learning disability. At Stanford this year, 45% of the class has 60s
in one of my big classes.
Okay, 60% of the Stanford college class has a learning disability.
Wow.
Okay, but not the learning disability could not have been so strong that they didn't get it to Stanford, but they get extra time for exams, and so the students take their incentives. They know what they're doing. Okay, and lastly, establish control of the composition of your community. Which is admissions process, which is kind of faculty hiring, faculty promotion, that they're kind of not letting each unit be totally independent in its decision making because there is the community and you cannot kind of in the commons and you cannot be selfish in taking from the commons, taking from the university of reputation, in order to enhance yourself, enhance your perspective without giving enough back. Okay, so to conclude, will these steps be enough? There may be, I think there might not be sufficient, but they're essential preconditions. Universities have a delicate balance of individualism and nonconformity on the one hand and of community at the other end. Both must exist. They are out of alignment right now. It is time to fix that imbalance. It's a generational project because it took a generation to get into this mess. It'll take a generation to get out of it. But it can be done. The time is now. And this conference is a step in that direction. Thank you.
Thank you, Eli. Our third and last speaker is Pnina is deputy head of the Curtin Law School in the Faculty of Business and Law at Curtin University in Perth, Australia. Her research is in the area of higher education law, protection of academic freedom and speech, and the legalities associated with university responses to student and staff misconduct. And she's also the president of Western Australia's Society of Jewish Jurists and Lawyers. And Pnina will talk about regulating anti-Israel speech in Australian universities while upholding academic freedom. Thank you, Pnina.
Is my slides up?
It should be. I don't know, who's responsible for technology?
Okay.
It's big, the font is
That's it?
So I just go like that.
So Israel has become a litmus test for everything now.
So can Australian universities regulate certain types of anti-Israel speech by their academic staff and students while still upholding freedom of speech and academic freedom? Now, to answer this question, I've got to note first that obviously issues concerning freedom of speech and academic freedom are not unique to Australian universities. That's very clear. But the Australian constitutional and legislative framework is different to that of other countries, requiring different responses to these issues. So the Australian Constitution does not expressly provide for the protection of freedom of speech, albeit that there is an implied constitutional freedom of political communication, which imposes limits on legislative and executive power. But freedom of speech does constitute a common law freedom in Australia, and it's even come to be characterised by the High Court, by the Australian High Court, as a fundamental right, albeit a limited and not an absolute right. On the other hand, academic freedom, so you'll see that I'm distinguishing between the two, academic freedom has a complex history and is neither expressly protected by the Australian Constitution or by the common law. So what provides academic freedom and freedom of speech in Australia with protection? And what are the limits, if any, on such freedom? Australia's current higher education legislation requires universities to safeguard freedom of speech and academic freedom, and it draws on what we call the French Model Code to do this. So essentially, protection of freedom of speech and academic freedom at universities and their limitations are found in the French Model Code. So what is the French Model Code? It's not something that was designed in France. In 2018, several specific incidents in Australia involving the attempted deplatforming of conservative speakers from at the University of Sydney and the dismissal of an academic called Peter Reid, who was deemed a climate change denier from James Cook University, had a significant impact in attracting Australian government, media and public attention and generating political action in relation to issues of freedom of speech and academic freedom in universities. And as a result, the then Minister for Education in the coalition government, we now have a Labor government, that was our previous government, commissioned in November 2018 an independent review of freedom of expression and freedom of intellectual inquiry in Australian universities. Now, bringing a hefty weight to this process, the review was to be headed by the then Chancellor of the University of Western Australia and former Chief Justice of the Australian High Court, the Honourable Robert French. So in March 2019, French released the report of the Independent Review of Freedom of Speech in Australian Higher Education Providers, containing a model code for the protection of free speech and academic freedom. All Australian universities subsequently committed to align their policies with the principles of the model code. And it has clearly become of critical relevance to the issue of freedom of speech and academic freedom in Australian universities. The model code provides that it prevails over non-statutory policies to the extent of any inconsistency, and many universities have now even incorporated the principles of the model code into their workplace or enterprise agreements, right? Albeit that the model code does not require the incorporation into enterprise agreements and workplace agreements, but a breach of a clause of an enterprise agreement, that's like an umbrella agreement with academic staff, constitutes a breach of the Fair Work Act, which results in significant penalties. And it's arguably the adoption of this model code that has resulted, at least in part, in the reluctance by Australian universities to take steps to manage anti-Israel and anti-Semitic speech on their campuses. So what does the model code say? Well, firstly, you can see here that the model code has three objects that reflect the importance to universities and to society generally of freedom of lawful speech, academic freedom, and institutional autonomy. So to ensure that the freedom of lawful speech of staff and students of the universities and visitors to the university is treated as a paramount value, and therefore is not restricted nor its exercise unnecessarily burdened by restrictions or burdens other than those imposed by law and set out in the principles of the code, to ensure that academic freedom is also treated as a defining value to the university and also not restricted by anything other than that set out in the code. And this is less relevant to my presentation, but also to affirm the importance of the university's institutional autonomy under law in the regulation of its affairs, including in the protection of freedom of speech and academic freedom. And you can see the model code provides for the enjoyment of freedom of speech as exercised on university land or in connection with the university by every member of the staff and every student at the university. And it also provides for the enjoyment of academic freedom by every member of the academic staff and every student. So in proposing the model code, French sought to settle the definitions and the parameters of both freedom of speech and academic freedom. Notably, the model code's definition of academic freedom is distinguishable from that of freedom of speech. So you can see here, this is the definition of academic freedom. You'll see that relevantly, you've got the freedom of academic staff to teach, discuss and research and to disseminate and publish the results of their research, the freedom of academic staff and students to engage in intellectual inquiry, to express their opinions and beliefs and to contribute to public debate in relation to their subjects of study and research, and then the freedom of academic staff and students to express their opinions in relation to the higher education provider in which they work or are enrolled. I mean, I'm just going to stop there, but this is the definition. These are the ones that are relevant to my presentation today. And you can see speech is defined in the model code simply as very broadly as extending to all forms of expressive conduct, including oral speech and written, artistic, musical and performing works and activity and communication using social media, with the word speak having a corresponding meaning. So while pursuant to the model code, academic freedom protects the freedom of academic staff and students to express and debate ideas and share information in relation to their subjects of their teaching, study and research, academic freedom does not protect speech occurring outside of this context, right? Although that sort of speech is protected by the freedom of staff to speak on campus or in connection with the university. There is another section which I'll show you shortly relating to the freedom of academic staff and students to express their opinions outside of a university environment if they are their personal opinions and so not on the basis that they are speaking for the university. So that's general public commentary by academics is granted a degree of protection elsewhere in the model code. So notably, French did make provision for some limitations on the enjoyment of freedom of speech on university land or in connection with the university and academic freedom in the model code. So what are they? So you'll see principle 1 of the model code provides that the enjoyment of freedom of speech, so now we're talking about freedom of speech of staff and students exercised on university land or in connection with the university, is subject only to restraints or burdens imposed by law, right? So what about lawful speech then? Well, universities can regulate it to the extent that is reasonably and proportionately necessary to the discharge of the university's teaching and research activities. The right and freedom of others to express themselves and to hear and receive information and opinions. These are all, by the way, not and, right? The reasonable and proportionate regulation of conduct to enable the university to fulfill its duty to foster the well-being of students and staff. And I'm going to show you shortly, this has a definition, right? Very important. The reasonable proportionate regulation of conduct necessary to enable the university to give effect to its legal duties, including its duties to visitors to the university. Similarly, Principle 3 provides that the enjoyment of academic freedom of academic staff and students is not restricted, except by similar prohibitions, restrictions, or conditions. Again, note this limitation. The universities can regulate speech reasonably and proportionately necessary to discharge the university's duty to foster the well-being of students and staff. Now, so what is this duty? This is the duty to foster the well-being of students and staff. This is how it's defined. The duty to ensure that no member of staff and no student suffers unfair disadvantage or unfair adverse discrimination on any basis recognised at law, including race, gender, sexuality, religion and political belief. And the duty to ensure that no member of staff and no student is subject to threatening or intimidating behaviour by another person or persons on account of anything they have said or proposed to say in exercising their freedom of speech. It supports reasonable and proportionate measures to prevent any person from using lawful speech which a reasonable person would regard in the circumstances as likely to humiliate or intimidate other persons and which is intended to have either or both of those effects. But note, the duty does not extend to a duty to protect any person from feeling offended or shocked or insulted by the lawful speech of another. Now, very importantly, you'll see here then that the Model Code expressly prohibits the university from finding a person's lawful speech on the university's land or in connection with the university's activity, subject to the reasonable and proportionate regulation, subject to the limitations that I referred to you, to constitute misconduct. So a university can't discipline anyone for lawful speech that is not limited by the restrictions that I showed to you that are set out in the Model Code. So to constitute misconduct, any penalty or other adverse action by reference only to its content. Now this seems to, actually no one seems to focus on this, and I come back to Einat and Ayala's talk here. So in terms of freedom of speech, they do seem to be saying that the university can regulate lawful speech by reference to its manner, right? But when it comes to academic freedom, the Model Code prohibits the university from finding the exercise by a member of the academic staff or of a student of academic freedom, subject to the limitations that I referred you to constitute misconduct at all, content or manner, right? Any penalty or other adverse action. Okay, let me give you now, so let me just summarise here. Under the Model Code, universities cannot regulate lawful speech which is merely offensive, shocking or insulting, but it can regulate humiliating or intimidating speech in certain circumstances. So the difficulty for universities then is working out what sort of speech is merely offensive, shocking or insulting, and what sort of speech is intimidating or humiliating. And that's the question that needs to be answered in relation to certain types of anti-Israel speech to determine whether Australian universities can regulate the speech on their campuses while still upholding freedom of speech and academic freedom. So to answer this question, we need to analyse the application of the principles of the Model Code to specific types of anti-Israel speech. So what I'm going to do now is to apply the principles of the Model Code to several real and hypothetical scenarios in which different types of anti-Israel speech are expressed by staff and students. Let's go to hypothetical example 1. This is an example that I adapted from a book called Open Minds, Academic Freedom and Freedom of Speech in Australia by Curtin Evans and Adrian Stone. We have a classroom debate. They didn't talk about Israel either. A classroom debate on Israel in a class regarding international law. One student argues vehemently Israel has a right to defend itself after a massacre of its civilians and the taking of over 200 of its civilians as hostages, and to destroy Hamas terrorist infrastructure to ensure that they do so. Another student argues, and remember this is a class on international law, another student argues that this cannot come at the cost of displacing the Palestinian civilian population or any Palestinian civilian casualties. As in the Evans and Stone example, some members of the class, including the lecturer, may have strong feelings in relation to either side of the debate and may feel offended or insulted by some of the arguments. Pursuant to the model code, does the speech of both students constitute academic freedom or freedom of speech?
Yes.
Academic freedom or freedom of speech? Remember that there's a distinction.
Freedom of speech.
No, it's academic freedom. They're in a class. This is their subject of study, right? So it's academic freedom. Under the model code, the speech of both students constitutes academic freedom, and protection is provided for both students to make their case. So neither student's speech would be sufficient to constitute misconduct nor attract any penalty or other adverse action by reason of its being offensive, shocking or insulting, and there'd be no difference in that case if this scenario involved academic staff as distinct from students. However, if the student in favour of Israel defending itself was to use a derogatory slur against their opponent and call them, for example, a Hamas terrorist, or if the speaker advocating for Palestinian civilians was to call her opponent a Nazi, it's not entirely clear from the wording of the model code whether the university would be entitled to regulate the speech. Would it merely constitute offensive, shocking or insulting speech and hence be protected by the model code? Or could it reasonably be regarded as humiliating or intimidating speech, with the speaker intending it to have this effect and thus able to be regulated? Might it be considered to be threatening or intimidating behaviour resulting from the other speech? Could it be argued that it disrupts the discharge of the university's teaching and research activities? The answers to these questions will determine whether a university in Australia can reasonably and proportionately regulate the speech while still upholding academic freedom in accordance with the model code. Here's another scenario. What if those derogatory slurs, personal attacks or loud and aggressive arguments in relation to Israel are expressed in the university corridors, unrelated to any classroom or academic debate? Is it academic freedom or freedom of speech then?
Freedom of speech.
Excellent. Assuming that the speech does not relate to the subject of the speaker's teaching, study or research. Of course, in that case, if it did relate to their subject, then it would be academic freedom. It would not constitute an expression of academic freedom pursuant to the model code. However, applying that distinction in the model code, it constitutes freedom of speech. Assuming that the speech is lawful, a university that respects and upholds the principles of the model code would again need to ask the questions that I did previously to determine whether they can regulate the speech. Does it merely constitute offensive, shocking or insulting speech, therefore protected by the model code? Or might it reasonably be considered to be humiliating or intimidating speech, or threatening or intimidating behaviour, and therefore potentially actionable? Does this exchange disrupt the university's teaching and research activities? In this instance, where the speech doesn't relate to the subject of the speaker's teaching, study and research, remember I told you that the model code also expressly provides here for the right and freedom of others to express themselves and to hear and receive information and opinions. Interestingly, that's not a limitation that's imposed in relation to academic freedom. There's also, as I said earlier when I referred to Einat and Ayala's talk, arguably no limitation on the ability of the university to regulate the manner as distinct from the content in which this kind of speech is expressed. So even if the university is prevented from regulating the content of this speech, the manner in which any derogatory slurs, personal attacks or loud and aggressive shouting is made that are not expressed or conducted in the exercise of academic freedom can arguably legitimately be the subject of university regulation and consequent disciplinary action. I'm just going to give you another example because I think I got just one more. Okay, I'll just give you quickly because this is a true example now. taken from the recent Australian full federal court case of the University of Sydney and National Tertiary Education Industry related to Dr. Tim Anderson. So Dr. Tim Anderson was a political economist at the University of Sydney. In April 2018, Anderson gave a PowerPoint presentation during a seminar. And his presentation included a slide containing an Israeli flag superimposed with the Nazi swastika with the heading, "Look for independent evidence and or admissions to test qualifiers with reference to Israeli assaults on Gaza as compared to Palestinian attacks on Israelis." Anderson subsequently posted the Gaza graphic to his Facebook account, which identified Dr. Anderson as affiliated with the University of Sydney. And he reposted that on his Facebook and Twitter accounts again later that year. Additionally, he posted on his Facebook account a photograph taken at a lunch in Beijing with one of the people at the lunch wearing a shirt featuring a shoulder patch with an emblem of, and I'll just tell you, when I actually studied this case, I didn't even know what this was, Ansar Allah, an Islamist group based in Yemen. I now know it to be the Houthis. An Arabic script meaning death to Israel, curse the Jews, victory to all Islam, right? This conduct, as well as other conduct engaged in by Dr. Anderson, culminated in the University of Sydney terminating his employment in early 2019. Anderson commenced legal proceedings against the university, arguing that his conduct constituted an exercise of his right to academic freedom, or intellectual freedom in that case, under the university's enterprise agreement. This was prior to the model code, by the way, being instituted. And so he said his activities could not constitute misconduct under the enterprise agreement, and Anderson argued that in warning and terminating him, the university had breached the enterprise agreement and hence the Fair Work Act, the legislation. As I said, model code wasn't in existence then, and the right to intellectual freedom under the University of Sydney's enterprise agreement allowed Sydney's academics to express unpopular or controversial views, provided that they did not engage in harassment, vilification or intimidation. They were also required to exercise this right in accordance with the highest ethical, professional and legal standards. The full federal court found in favour of the University of Sydney, with the majority deciding that they could not be satisfied that Dr. Anderson's comments met the highest ethical, professional and legal standards, and therefore whether they constitute an exercise of intellectual freedom protected by the relevant enterprise agreement. However, I'll just say, because I've got to finish up, the model code doesn't have those standards, right? So the question is, are they implied, right? And look, I'd like to go in, I think Moran mentioned the purpose of academic freedom. If we look at the purpose of academic freedom, and even the legislation talks about the purpose of universities being to advance truth. To me, if that's, if academic freedom is not doing that, then I think, you've basically sacrificed the privilege of academic freedom. But anyway, I can't, I've got more to say, but I can't say it now. So all I'll say is, while the model code has gone a significant way in protecting and promoting academic freedom and freedom of speech on Australian universities' campuses, there's clearly still work to be done in ensuring that the protection of these freedoms does not come at the expense of the well-being of the university community. Further clarity and direction clearly need to be provided in relation to the model code. My PhD provides that guidance. But I wrote this presentation actually prior to the massacre at Bondi Beach in New South Wales, and had concluded at that time that it may take a case involving anti-Israel speech to come before the court now, as post-model code, to provide that clarity, and that in the meantime universities should not shy away from interpreting the model code in a way that protects the safety of their students and staff while still upholding freedom of speech and academic freedom. But I now consider that unfortunately it may take government intervention and possibly even legislation to provide this guidance.
What a tour de force. So thank you, and we can see how these three presentations are actually connected, and how what Pnina talked about, content versus manner, maybe Einat and Ayala, you want to comment on that. And I just wanted to raise initially two preliminary points. The first is, I think it comes out of these presentations that a community is something that is constructed. Okay, so when we talk about an academic community, it's not a village in India where everybody, it's something that we actually create and constitute through structures, through codes, through norms. Okay, so our business is not just taking community as a given, as a pre-existing entity, but rather the policies that we implement and the structures take part in building a community. And I think when we talk about community, we talk about a responsibility to each other. We talk about some type of relations that people have, and I think we are really talking about what our responsibilities are towards each other when we create those norms and structures and policies. And I think these are all good examples of what this thing community can mean. My second point, I thought when Pnina talked about, and it was really very hard to follow, but I tried from my position there, and you said that the regulation of speech is either on university land or in connection or in relation to the students' affiliation with the university. And I think Sharon talked about it in the first session. We now have regulation of speech we did it in Tel Aviv, private Facebook. Okay, people post on their private Facebook things that may be derogatory, that may be inciting, that may be unlawful, but have nothing to do with them being students at the university. They just are students at the university. And what do we do about that? Do we extend our jurisdiction also to the social media, which now is the corridor, right? Of course, if it happens in the physical corridor, we have jurisdiction over that. But does it also justify regulating speech on private social media platforms, because everybody's there anyway, and they see and they get insulted and offended and hurt by what somebody wrote on their Facebook. So all these issues, I think, are connected to this delicate balance between free speech and community. So I think you can stay in your seats. You don't have to come here. It's very uncomfortable to sit here. So if any of the presenters want to comment, or somebody from the audience.
Neta?
יש presentation online.
Oh, we have
Brother is
another.
watching you.
There's another presentation?
No, this is it.
That you said that I couldn't come. You
Right.
mentioned at the beginning.
No, but somebody was
Somebody called
speaking.
you. Somebody
It was
called
not
Neta.
God.
Big brother is watching you.
Yes.
Sorry, I didn't realize that there was
Oh, someone else here who's gonna.
but
No one is Zoom.
You're making a
who called me? That sounds like a biblical,
Yeah, I also have to present. I just didn't want to interrupt.
there
and
you
I
go.
didn't.
I see.
I don't know if you still have time, but I'm trying to email you.
יש לך גם זה זום.
So sorry.
תעשי escape מהפאורפוינט.
It's in the three aspects.
Okay. Neta, I'm so sorry. Nobody told me that you're actually going to be presenting.
I only told them this morning because there was hope that I would still make it. I was in the consulate for the past 2 days trying to convince them to let me come. So I don't know if you still have time. I can give it as a brief version, but I also don't want to cut short the discussion. So.
First of all, I'm very sorry that you couldn't come. And please take, if you can, 10 minutes.
Sure.
To make your presentation, and we will cut the discussion. Sure, I was talked too much.
Okay. Yeah, thank you so much, and I'm so sorry I couldn't join you in person. I found out on Saturday morning that my ETA was revoked, and it had been given to me 2 weeks prior. So I don't know if it has to do with the political situation here in New York, where I'm from, and some of the executive orders that were passed, but I spent the past few days in the consulate and in conversation trying to find a way to come. I'm very happy to be presenting and to be with such an esteemed group of presenters, and I'm very passionate about this work and these issues. So since we don't have a lot of time, I had a slideshow prepared, but I'll just give a quick synopsis maybe. I don't know if the slides are visible, are they?
No.
Okay, so there is a slideshow, but I'll just give a quick synopsis of my paper. I really enjoyed listening to all of the presentations, and really believe so firmly in this idea that that the university is a community of listeners. And so my own experience, the preface of my paper that I start with is just explaining that I myself experienced a hate crime as an undergrad, my first week of college at Brown University. And someone wrote the word terrorist all over my door. And it was less than a year after the events of 9/11 and before the Iraq War started. And this event kind of changed the course of my life and has influenced a lot of my work as a journalist and as a scholar. So I study auto-censorship and freedom of expression, the regulation of online platforms, and surveillance and source protection. Those are my areas of interest. And a lot of that experience, it made me study abroad at the American University in Cairo and also in India as a Fulbright scholar, where I was looking into hate speech between Muslims and Hindus. And that exposure, I also attended medical school at Mount Sinai in New York, which is a historically Jewish institution. So those experiences of exposure to hate speech really have influenced the work in this paper, which is about the concept of incitement to violence that comes up in the case Brandenburg v. Ohio, which is a seminal Supreme Court case in the US that has shaped the idea of how violence should be framed and understood, and has given broad protection to all speech, including hate speech. And so in my paper, I argue that while this is a really important Supreme Court case, it was also a case that came up in the 1960s at a very different time. And we've seen this rapid rise of hate, both online and offline, in the past few years, and that universities as private institutions and also public institutions, I know, have to abide by First Amendment precedent, but should be able to deal with hate speech in a slightly different way without being fearful of curtailing freedom of expression. And it's something that I've debated and tried to understand in both personal ways and in scholarly ways for the past 20 years, but it's basically the idea that we need to start thinking about as words as violence. And I draw on both psychology and sociology and also a lot of spiritual and religious traditions that talk about the emotional body and the impact of words on the person, and the need to acknowledge that while also maintaining freedom of expression. So it's something that I think it's really important to reframe as a normative concept, not necessarily as a legal concept, that the First Amendment protections offered by the case Brandenburg are really important to protecting free speech broadly, but given the rise in anti-Semitic speech, given the rise in other forms of hate crime that are really well documented, there's a space to start to change the norms of how we think about language, and to do that on the college campus, and to really allow students to feel safe and to feel comfortable in discourse. So it's really an attempt to balance these two perspectives and to understand that they're not actually incompatible at all, but really go hand in hand. So some of the things that can really help, one of the things that I advocate for is to not have overly harsh disciplinary measures towards hate speech, but to really engage in programming and training. And a lot of people in this conference have alluded to that, to different forms of exposure and discourse for students to understand limitations and to understand the impact of their speech. It's very possible to consider the university as a space to learn how to speak and to learn how to talk about politics without making it personal. And so the Brandenburg case sets out two standards for how to test whether speech, there's a very tiny exception of speech that is not protected by the Constitution, and speech that incites imminent violence and speech that is also likely to incite that violence. So it's not just the immediacy, but also the likelihood. So that involves an analysis of the context in which the speech is occurring, the atmosphere, and kind of the history of violence within the community. Those are very, very important legal norms, and those legal norms exist in large part so that the government can't curtail our speech, and that's an essential freedom that legally we should uphold. But the university is a space for people who are young and maybe in their first exposure outside of the home, their first exposure where they're having to rethink their identities or be confronted with certain stereotypes. And so the argument is that outside of the Brandenburg test, that we can have sort of other modes of evaluating what our expectations are for the environment that we produce for students. So one of the proposals that I have in this paper is that a student should be able to not participate in politics. And so the university should insist that all demonstrations should be nonviolent and teach nonviolent techniques. And that's something I feel very strongly, that this idea of non-participation, that people come to college or to university with different experiences of trauma, with different tools at hand for resilience, for healing, and non-participation is very, very important, but also engaging the actual community of students about what speech they're impacted by, what their experiences are, engaging in more surveys and more documentation, more oral histories, to understand the nuances of speech and kind of increase the level of granularity. So a lot of the debates in the past few years about what speech is genocidal, what speech is hate speech, which speech is anti-Semitic, which speech is hateful towards the Arab community. I mean, a lot of those debates feel like they could have been de-escalated if we had just taken sort of a higher level of granularity and understood that these are really, really thorny issues, but the college campus doesn't need to be the locus of this discourse. It should actually be occurring in a larger context in the society, and that the college campus can provide different norms than the legal ones that are set forth by the First Amendment. So I don't want to run over time, but that's just it's a very, very quick synopsis of what I was planning on presenting.
So Samantha, thank you very much. It's right on, actually, in a continuance of what we talked about. Hate speech is a very good example on the difference between the larger community, what we expect on campus. So I really thank you for kind of pointing to this difficult issue. I can tell you that in Israel, at least in my university, we do not tolerate hate speech. Yeah, hate speech is one of the behaviors or speeches that do not enjoy the protection of free speech. So on that, I'm definitely with you. Well, thank you.
Thank you.
Thank you. I'm sorry I didn't know you were joining us. And
That's okay. I think it was a miscommunication, but thank you. It's very good to be here.
Okay, so we are concluding. Thank you, everybody. We have a break.